one thing that I tend to find most effective is just trying to find a creative solution. The banks see so many of the same things over and over. When you hit them with something creative, whether it's in litigation or if it's a modification or short sale, it piques their interest a little bit. And realistically, far more of these cases do actually resolve themselves in some way, rather than end up in a foreclosure sale. Again, if you look at the grand scheme of things with so many sales out there, the reason is so many people go unrepresented. That 10% that do get attorneys, it really is surprising how many of those cases actually do resolve themselves without ever getting to a foreclosure judgment or sale. Yes?
Yeah, you said that the bar doesn't like the monthly fee arrangements. How would you suggest? What's the average cost to the client?
Well, what I do, this is just from experience, is your work in a foreclosure defense case is going to be most intense up front. It's going to be the review, getting whatever pleadings you need to file done. So I ask for a reasonable retainer in most of these cases. I ask for $1,500, which in the scheme of most of my lawsuits is fairly small. After that, I tell my clients to expect anywhere from $0 to maybe $500 a month in billing. I bill them on an hourly rate. I tell them that depending on what's going on, it may go over that $500. Because if we're going to mediation, we're going to prepare for it, we're going to sit in mediation. Mediation may take 2 or 3 hours. And then they need to expect to pay the cost, possibly pay half the cost of a mediator if it's not in the county where the courts are requiring the lenders to pay that. And then there may be copy costs and discovery, things like that. The foreclosure from start to finish in defense can run anywhere from $1,500 to $10,000. Has been what my outside experience has been on some of these cases. Typically, it's a lot less. It's going to be in the $3,000 to $5,000 range, and again, depending on how quickly the case moves along. If it's $5,000, but because of issues with the lender's counsel, it takes a year. It's still that works out to under $500 a month. And if you ended up not defending and having to get an apartment, and giving up your 4-bedroom, 3-bath home, it's probably a very good deal because you probably haven't paid your mortgage in at least 90 days prior to filing, more likely 6 months. If it goes a year and you still haven't paid your mortgage, that's a lot of money into somebody's pocket. One of the things that I'm seeing a lot of out there also now is people where they are defending or they're just, they're a Dade County case where it's 9 months to sale, is people are putting that cash in their pocket, and before the foreclosure goes through, they're buying a new piece of property with the cash they saved, qualifying for the loan while they still have good credit, and then walking away from the last house. I'm not saying it's a good thing or a bad thing, it's just a fact of what people are doing. Yes?
Kind of going off with them, do you find it sometimes hard to collect from clients, considering the situation they're in?
Well, one of the things, and I'm just going to talk a little bit about client relations going forward here, that I make sure all of my clients understand is if they don't pay, I don't work. I withdraw from the case. And it's very clear, and it's in my retainer agreement that they're required to pay within a certain period of time, whatever is outstanding. If they don't pay it, then I will not continue to work on the case, and I will withdraw from a representation. That's a foreclosure defense or anything else.
Most of them run 12 months or so, and they can expect to pay, like on an average, $300 or $400. A lot of them receive $500 a month. Like if I was walking into your office foreclosure, odds are I'm going to be paying $500 a month for the next 12 months.
Well, again, if you come in today and go through everything, and you're close to your 20th day to respond to the complaint, and I file a motion to dismiss, and it happens to be one of these mill firms on the other side, and I file it before the end of the month, I can probably assure you with almost complete certainty that you're not going to see a bill for legal services in the month of November because nobody on the other side is going to pick up on what to do with that motion to dismiss. Now, if I have to handle the motion to dismiss, go to motion calendar and go to court, you'll get billed for the time. I try to make sure that, especially with sensitivity to foreclosure clients, what their cash situation is for most of them. I try to make sure I'm going to court on other matters at the same time so that I'm not charging them from door to door to go sit on a 45-minute calendar where I have to sit for 45 minutes or an hour just to get my 5-minute hearing.
And then why was that arrangement better than one a month, like every month?
Well, the other arrangement that's out there that I've seen a lot of is the non-refundable $500 a month, is that it is non-refundable even if there are no legal services done. That's why I was using that Miami-Dade example where I know a couple of lawyers who have their clients continue to pay after judgment to the date of sale. They're paying $4,500 for nothing.
I know that when people are in foreclosure, they're also usually not paying their association dues.
Right.
Do you have any involvement in those types? Because I know that the associations can foreclose also, and that maybe the banks might not want to foreclose because of that.
It does happen. I will tell you, though, that my experience has been typically the associations don't want to go and incur the expense of going through a foreclosure when they're behind a mortgage or two. There are some that do. One of my clients was foreclosing on a condominium down in Miami. The association started their foreclosure at the same time, took title, and held title for about 2 months before my client got its certificate of title. They rented out the property, they got some income to offset what their losses were. But of course, when we took title, the property became ours. We ended up working something out with that tenant. One of the other things that is out there in addition to association are tenants. A lot of properties are rented out. Up until fairly recently, you could evict a tenant as a lender without, once you got your certificate of title. The tenant got title or was vested with your possessory interest through the prior owner. There's now a law out there that protects tenants in foreclosure. And if the lease was entered into fair market value with a non-relative prior to the start of the foreclosure, as a lender, the lender must honor the rest of that lease. Unless the buyer of the property was going to occupy it as the primary residence, in which case they give 90 days notice and the tenant has 90 days to vacate. So there's some tenant protections now too.